Thanks, Andre. So now that Andre's provided a bit of refresher, I'm sure everybody's already watched the video, but he's provided a refresher on really what CASL is all about. We're going to look at the regulations and the guidelines. I'll probably take about 45 minutes. We'll leave 10, 15 minutes at the end for questions, but if anyone has any questions throughout, please throw up your hand. So because the regulations build on what's in CASL itself, the interpretive guidelines build on the regulations. We're going to start by looking at the three primary rules that are under CASL with respect to commercial electronic messages. Then we'll move on to the regulations and then the guidelines. We're also going to look at the rules that apply to installation of computer programs. We haven't really covered those in the past that I'm aware of, so some of that might be a little bit new. So Andre briefly spoke to this, but CASL creates three primary rules when it comes to sending commercial electronic messages. First, and most importantly, we always need consent. We have certain identification requirements that apply. These are clarified in the regulations as well as in the interpretive guidelines. And we also have the unsubscribe requirements, which everyone is probably already generally familiar with under CAN-SPAM. CASL is a permission-based regime, except in limited circumstances where we have some exceptions, but in most cases, we always need some form of consent before we can send a commercial electronic message. And according to the Act, consent is either express or implied. So to start with the implied consent provisions, there are 4 specific sets of scenarios where we can imply consent, and these are really more of, probably more accurately described as deemed consent. So the first is the existing business relationship, or EBR. There are a number of subcategories of the EBR. So if the recipient has made a purchase from the sender within the past 2 years, or if the recipient and sender have been involved in some sort of contractual relationship, like a magazine or phone subscription, then it's okay to follow up with a message within 2 years of the expiry of that contract. So it's a pretty generous provision. The existing non-business relationship is the counterpart for non-business type relationships, so charitable relationships, if somebody has volunteered for a political party. Again, similar time periods in there, likely less relevant for most people here. And then the last 2 categories, we have conspicuous publication of electronic address. So if the recipient has conspicuously published their electronic address, for example, myself as a lawyer, I've published my email address on my website, then you have implied consent to contact me with two important conditions. First of all, the message has to be related to my business or official capacity. So if you're marketing legal publication to me, that's probably okay. If you're trying to sell me football tickets, that's probably not okay under the legislation. And also, obviously, if I have any sort of statement below my electronic address saying don't contact me, then you can't contact me. And number 4 is very similar. It's where I've actually provided my electronic address directly to the center, so I've provided my business card as an example, but again, it has to be related to my business or official capacity. So those are the implied consent provisions. We always look at them first to see if we have some sort of implied consent based on our relationship with the recipient. If we don't, sure.
Just want to make sure if we've got a situation where I have a business relationship or a non-business relationship, but I've not provided my email address, do these other parties have the right to take my mailing address and do some e-pending to perhaps derive my email address and then start sending and then claim protection under the pre-existing relationship?
It's a good question, because if you have this sort of relationship and you have their electronic address, it kind of begs the question, well, why didn't you just ask them for consent in the first place? It's a really good question. If I already have some sort of other information about you and then I do some email appending, strictly speaking, under the legislation, you're probably not going to violate CASL by doing that, because CASL doesn't say anything about that as long as you have that implied consent relationship. Now, we also have to keep in mind privacy legislation. So if you're collecting somebody's email address without their consent, that's personal information. You're probably violating privacy legislation. And does that answer your question? Okay. So if we don't have implied consent, we need express consent. The law itself doesn't say a lot about exactly what express consent is. I think that might have been partly intentional to leave flexibility, but we'll look at the CRTC regulations and the guidelines, what they have to say about express consent. But the CASL itself says that we need to describe the purposes. So why are we asking for consent? You're consenting to sign up to my newsletter, or you're consenting to receive information about offers from my company as well as this company and a third company. We have to provide identification information, which is prescribed in the regulations. And then, as I said, the regs and the guidelines really provide more clarity on exactly how we go about doing this. Identification information, when we're asking for consent or every time we're actually sending a commercial electronic message, we have to identify the sender. So we have to provide a business name for the person who's sending the message. If it's being sent by one person on behalf of another person, we have to identify who that person is as well. We have to provide contact information for either one of those persons. And the law says that the information needs to be set out clearly and prominently. Now, in terms of exactly what this means, I really think they're trying to develop a common sense approach to this. So if you're using 8-point font in a light gray color on a dark gray background, it's probably not going to meet this test. So really have to use common sense. It has to be clearly available for the recipient to be able to read it. The unsubscribe mechanism, no real surprises here. Largely similar to canned spam. It has to be functional for 60 days. The recipient has to be able to unsubscribe at no cost. The same means and less impracticable. And really what this means, if you're sending email, don't require the recipient to call a telephone number in order to unsubscribe. And we have to process it without delay. Sometimes there's a little bit of confusion around what this means, because the law says without delay, or in any event no longer than 10 business days. So the safest approach to take is really, to the extent possible, make sure that no commercial electronic messages are sent after an unsubscribe request is received. Obviously, there's going to be cases where that's not possible. If there's a good reason, for example, a mail-out is already in the queue and it happens to go after the request is received, I don't think that that's going to be a problem under the legislation. But again, take all those efforts to make sure that the unsubscribe requests are processed as quickly as possible. And the installation of computer programs, again, this is a little bit new. I don't think we've really discussed this very much at MAAWG, but some of these rules are obviously very important for a lot of MAAWG members. In all cases, we need express consent before installing a computer program. Similarly to when we're requesting consent to send a CEM, we need to describe the purposes. So what are we doing? We're installing a computer program or a mobile app. Provide the prescribed information, which is similar. We have to simply and clearly describe the function and purpose of the computer program in general terms. Another requirement that pops up when we're thinking about certain functions of the computer program, the law specifies a number of specified functions that have to be brought to the specific attention of the user outside of any end-user license agreement. We have to describe the material elements that perform the functions, including the nature and purpose and reasonably foreseeable impacts on the operation of the computer system. So what are these specified functions? I'm not going to go through them in detail, but these are really some of the more nefarious types of functions that we might see in spyware or malware, even though there are legitimate programs that might do some of these things. For example, collecting personal information that's stored on a computer system, interfering with the owner's control of the system, doing things like reaching out and communicating with a third-party computer, or reaching out and installing third-party software without the knowledge or consent of the user. So if the program does any of these things, we have to bring it to the specific attention of the user. The kind of ironic thing here, though, is if the computer program is doing any one of these things and it's more likely to appear in something that we would consider malware, and in those cases, whoever's actually installing the computer program is probably not as concerned about following the rules. So really what this ends up being, I think, is another level of violations that would be committed by anyone installing malware, and another way to effectively go after these people. So moving on to the CRTC regulations, they were finalized in March of this year. There were several changes from the first draft of regulations that were published in July of last year. There were a lot of stakeholder comments on the CRTC regs. I'd say more on the CRTC side of things than Industry Canada. There were concerns about some of the requirements in there being particularly onerous in terms of the identification requirements. Some of the regs would have effectively required multiple forms of unsubscribe mechanism, a huge list of identifying information. It would have effectively required every single organization to have a web address, which may seem like a simple thing, but for small businesses that could be a fairly onerous requirement. So fortunately, the CRTC listened to a lot of these comments, made a number of changes, and the final regs that were published in March, I think, were a lot more reasonable and more in line with existing business practices. So the regs really focus on the information that has to be included when we make a request for consent and every time we send a commercial electronic message. They also speak a little bit to the form of unsubscribe mechanisms and how to obtain consent for the specified functions in computer programs that we talked about. So information in a request for consent. Again, CASL requires that certain prescribed information be provided when we request consent. The regs say that we need the name of the person seeking consent or the name by which a person carries on business. I think what they mean here is if you have a number company, we'll then use the name by which a consumer might have actually be familiar with you, or the name that you use to carry on business. The name of the person on whose behalf consent is sought, if different. If we're seeking consent on behalf of another party, we identify who they are. We also identify who's seeking consent and on whose behalf consent is sought. Contact information for either one of those persons, which includes a mailing address and any one of a telephone number or an email address or a web address. I say separate from unsubscribe. Even though we have to provide this contact information, such as telephone number, we don't actually have to allow individuals to unsubscribe by using the telephone number. The original draft of regulations would have. And we also need to include a statement that consent can be withdrawn. Very similar requirements in terms of the information that we have to actually include in every commercial electronic message. The name of the person sending, again, if it's being sent by one person on behalf of another, identify both of those persons, and also identify who is sending and on whose behalf it's sent. Contact information. The information has to be set out clearly and prominently again. The prescribed identifying information can be included on a web page, so a link out to a web page if it's not practicable to actually include it in the message itself. And the most obvious example is an SMS message. We only have 140 characters, so we put in a small URL that would then lead us to this identification page. I think in most cases that's probably the only practical way to actually do this. And the form of unsubscribe mechanism, the regs say a little bit about this. The first draft that was published last year said that an unsubscribe must be able to be performed in no more than 2 clicks or another method of equivalent efficiency. There were a lot of comments on this. Obviously, it would be problematic if we actually used an opt-out page. You could exhaust those 2 clicks pretty quickly, so we have to click on the link to get to the page. And then if we have any sort of choice at all, the user might be required to click 2, 3, 4, 5 times in order to specify their preferences and then opt out. So there are a lot of comments on this. The CRTC went back to the drawing board and came up with something that was more similar to what we see under CAN-SPAM. So the unsubscribe must be able to be readily performed. So a more flexible standard that I think allows for a little bit more of a common sense approach. The specified functions of a computer program. So the regulations say that the material elements that perform any of those specified functions that we talked about that are listed in CASL must be brought to the attention separately from the other information. So we need separate paragraphs of information describing what these purposes are. We also need separate checkboxes, which we'll talk about a little bit under the guidelines for each one of those specified functions.